Because the truth is, this is a map attached to their application, their request in 1959. And so they like to call it Annex 1 map, and people would tend to think that this is annexed to the 1962 judgment, and that's wrong, completely wrong. Now, this map is show a boundary of about 100, more than 100 kilometers. But the part that concerns us is here. The temple, the boundary. This map was published as a result of demarcation work of the Joint Commission, French and Thai Joint Commission. The work was conducted in 1904-1906. In this area, it was early 1906. And it was drawn and published around 1907-1908 period. And this map was considered by the court in 1962 as binding on Thailand and France, so Cambodia as successor state. But after the judgment, for 50 years, Cambodia has been using this as a leverage against us all the way on, all the way through. Cambodia's position up to this point, up until this judgment, was that, perhaps still is that, the Annex 1 map line, the boundary line on it, is binding on Thailand for the whole series. We have 11 sheets of this series. Well, some of them do not apply anymore, but it goes for many hundred kilometers. So Cambodia says, because of the 1962 judgment, this boundary is binding on us, and they never wanted to negotiate the boundary with us, because they said there is no need to negotiate. You just look at the 1962 judgment. It's a great victory of Cambodia over Thailand, and so binding on Thailand. The third thing we obtained from this interpretation, which is requested by Cambodia, not us, now, is that outside of this area, the Annex 1 map line is not binding on Thailand as a result of the judgment. It could be binding on Thailand, yes and no, I don't know. It's subject to negotiation. General international law applies. We have to negotiate in good faith on the basis of international law, but not the 1962 judgment. The ghost of the 1962 judgment is gone forever. The ghost stays only for this part. But how large is it? That is the question. Now, all that I said, about this line not binding on Thailand anymore as a result of the judgment it can be found here and there, but the clearest place is here, 78 at the end. The court, having defined the disputed area in the former proceeding as a small one, referring to page 15 of the judgment of 1962, confirmed that while the Annex 1 map deals with a part of the frontier region of more than 100 kilometers in extent, the court made clear that it had to pronounce upon it only in the disputed area. Only in the disputed area. And the disputed area is defined here, qualified as small one. Now the French text is even clearer. La Cour a clairement indiqué qu'elle ne se prononçait en faveur de la ligne. In English, it's pronounced upon it. Here, it's prononcé en faveur de la ligne. Seulement pour la zone litigieuse, as defined here, était d'une superficie réduite. So now, Cambodia's claim has been reduced dramatically to whatever the court says on page 15. That is a court in 1962. That is, the temple of Viharn stands on a promontory of the same name. Promontory of the same name. So for the court, the disputed area is the promontory. Promontory. Then the court proceeds to define the promontory in 98 and impose on us through 99 an obligation to negotiate with Cambodia to find out on the ground where it is. We'll come back to that later. So what does it mean, promontory? In paragraph 98, the court gives us the definition of it. From the reasoning in 1962 judgment, then it gives a description of the promontory. And 99 tells us how to find the limits of the promontory on the ground. I'll come back to that. I have to be fair. I said at the beginning that we think it's a balanced judgment, and it's a bit more balanced for us. So we gain three things. So we have to lose something, right? So we've lost one thing. We have lost one thing. We have lost our version of the limit of the vicinity as defined by our Council of Ministers in 1962, the famous cabinet line. That one. Yes, that one. You remember the tip of the, again, look at the tip of, okay, you can take this. Look at Cambodia's claim. This is the tip of that claim. And the cabinet line is just about this. Okay? So this is the original cabinet map submitted to and decided upon by the cabinet in 1962, the original map. We lost this, and it's quite a heavy loss, because it means that what is our understanding for 50 years of the limit of the vicinity has now been rejected by the court, just as their understanding. But the reasons are different, because the origins are different. Their version is a transposition of the Annex 1 map line. Our version is a line drawn to implement the 1962 judgment on the basis of what we understood during the original proceedings of the vicinity. And we draw this line because we still think that is what Cambodia wanted in the original proceeding. In the original proceeding, they showed a line that is similar to this and not the larger area that they claim today. So in 1962, we thought that, this is roughly what they wanted, so we gave them that. The court says, no, the court cannot accept this interpretation by Thailand. Not because it's not a correct transposition of the Annex 1 map line, I told you, but because of two pieces of evidence. In 1962 proceedings, just a minute. These are two pieces of evidence, one by our experts and the other one by one of our lawyers. Just a minute. Yes, it's paragraph 85, 86, 88. Yeah. When the court considered our line, the court says the court think it must begin with examining the evidence that was before the court in 1962 regarding the locations at which such Thai personnel was stationed. You remember that the second operative paragraph talks about withdrawal of forces from the vicinity. So the court concludes today that vicinity is defined in terms of place where there was or there were Thai forces in 1962. It could not be any other place, but a place where there were Thai forces. And then the court proceeded to examine many evidence, and they found two evidence. One is given by Professor Ackerman, who was our map expert, and who said there was a detachment and frontier police and one temple guard. And these people were at a camp located to the northeast of the temple. And the guard lived in a separate house there too. But where then is the location of this police camp? That's where the second piece of evidence came in. An evidence, a statement by a lawyer, a counsel, saying that the police camp was north of the watershed as claimed by Cambodia in the former proceeding. So the court put one and one, that makes two. The two evidence show the court, and quite rightly, that the police camp was situated north of the cabinet line. It was situated around here, according to Mr. Ackerman and the Thai lawyer. So it was outside the area given by Thailand to Cambodia. So the court concluded that this line must be rejected. So that's the only thing we lost in this case. We obtained 3, we lost 1. But what is important is for those 3 things we obtained, they are non-negotiable. Non-negotiable. Cambodia cannot come to us and say, I want to negotiate this and that. They are non-negotiable. Dead and gone with nails on their coffin. We don't want to talk about it anymore. But what we lost here is negotiable. Why is it negotiable? Because you have to replace this cabinet line with something else. And the court says you replace it with the Annex 1 map line, but the transposition must be negotiated and it must be agreed upon by both sides. The transposition of the line, agreed by both sides. 2 conditions. Negotiation must be in good faith. Secondly, unilateral solution is not permitted. So that's the nail I told you. Unilateral solution is not permitted. That's the nail on the coffin of the green line. This is the Annex 1 map line as transposed by Cambodia. Let's look at how they did it. I say it again, in the old proceeding, in the original proceeding, they did not transpose the line this way. They transposed the line just about the way I show you now. The cabinet line. Now in this proceeding, they changed their position and then they transpose it like this.